Appeal, Cartier International and BT Plc.
I think you may have just switched it off, actually.
Thank you.
Yes. Well, we'll know shortly whether we can hear you.
My Lords, good morning. Thank you very much. I appear on behalf of the appellants with my learned friend, Mr. Reardon. My friends, Mr. Speck and Mr. Brandreth, are here on behalf of the respondents. My Lords, this case concerns injunctions to block the appellant's customers from accessing websites which advertise counterfeit versions of the respondent's goods. It is a new kind of injunction held to fall within the court's inherent powers to grant injunctions as reflected in Section 37(1) of the Senior Courts Act. The issue in this case is who pays for the costs of these injunctions, the appellants or the respondents. We say there is a clear and consistent principle from authorities involving injunctions against innocent parties to the effect that they are entitled to be indemnified against the costs and expenses of discharging the injunctions. We say this principle applies to the injunctions in this case for three reasons. First, because of the fundamental features in common with the injunctions in this case and the other types of case where the principle has applied. Second, because of the analogy with Norwich Pharmacal relied on by the Court of Appeal to support its conclusion that the appellants owed a duty to assist and should be susceptible to an injunction in this case. We say that the court should have followed that analogy through to costs. Thirdly, we say the principle applies in this case because Article 11 of the Enforcement Directive expressly Recital 59 of the Enforcement Directive expressly provides that the conditions and procedures of injunctions against intermediaries, such as internet service providers, are a matter of national law. And that takes us right back to the general principle. The respondents in their written case do not appear to challenge the proposition that there is an established approach in English law to the costs in respect of injunctions against innocent parties. However, they say the issue of costs in this case should be considered from the perspective of EU law, which somehow displaces those national law principles. They accept that there is no express requirement in any EU legislation to this effect, but they argue that it is implicit within the structure and framework of EU law that the internet service providers should pay. In particular, they say that there is an implied obligation to pay blocking injunctions in return for the benefit of the immunities or safe harbours available under the e-commerce directive. Now, these immunities can exempt a service provider, like the internet service providers, from liability arising out of the transmission of information between third parties. But the issue of immunities in this case is a complete red herring. First, because the safe harbours simply do not apply in this case. They are not engaged because the appellant internet service providers do not infringe trademarks. It's never been suggested that they do. Secondly, the arguments about safe harbours in respect of copyright are also wrong for reasons I shall explain. But
Is there an argument about that based on a European court case which is cited in the cases to the effect that the ISPs do communicate in a way which would involve an infringement? Is that an argument we've got to consider?
Well, my Lord, I'm going to come on to it and explain in detail this morning.
So it is an argument.
Why it doesn't apply in this case.
Yes, all right. Yeah.
The third reason, it's a red herring in any event, is because this quid pro quo argument is simply not supported anywhere in the text or the structure of the EU legislation and is nothing more than a circular point. The respondents also argue that different policy considerations apply in this case, which justifies a departure from the established approach in English law to costs of injunctions against innocent parties. They say that the internet is new and should be treated differently, but in fact, online counterfeiting is merely a new medium for an age-old problem. They try to give the impression that the internet service providers are not really innocent and are somehow much more culpable than other kinds of innocent parties who get mixed up in other kinds of wrongdoing. We simply don't accept that, and in any event, English law does not rest on degrees of innocence. Either you're a tortfeasor or you're not. They also try to suggest that the internet service providers are like host providers or platforms, such as YouTube, Facebook, and Google, and that they really ought to be taking the same kind of voluntary approach as those platforms do to removing illegal content. It's important at the outset to understand the differences between internet service providers and online platforms. Internet service providers are telecommunications companies that provide access to the internet for their subscribers. They provide the cabling and the physical infrastructure to connect customers with the internet. They don't provide the content on the internet that customers can access. They don't store or host that information. They're a bit like a postal service. They transmit the packages of information from the sender to the recipient, but without any input themselves as to the content of the envelope. In contrast, a host or a platform stores the information. And over the years, platforms have developed a voluntary procedure to remove illegal or tortious content when it is notified to them. And as we shall see, they do this so that they can take advantage of the immunities available to them under the e-commerce directive. But those immunities are different to the immunities available to internet service providers. Because internet service providers don't host any information, there's nothing that they can take down. What they can do is configure their networks to block access by their subscribers to particular websites when ordered to do so. Now, the technical details about blocking aren't important for present purposes. If my lords need more information, it's set out in the Statement of Facts at paragraph 28. But the process of blocking entails costs to the internet service providers. There's the costs of implementing the order, which breaks down as follows. Firstly, there are the initial costs of activating the block. Secondly, there are further costs in updating the block as websites move from one location to another, and that can be done up to once a week upon notification from the respondents in this case. And thirdly, costs can come about by dealing with problems that arise from the block, such as inadvertently blocking access to lawful content, a scenario or phenomenon that's sometimes referred to as overblocking. In addition to those compliance costs, there are also, of course, legal costs. Both types of costs are an issue before my lords today. It's important to understand that the internet service providers cannot block voluntarily because of the restrictions imposed upon them under the network neutrality regulation.
Where is that?
That is in Bundle 3, tab 39, page 1281 of the electronic bundle.
So that means what? You have to go to succumb to a court order?
Exactly, my lords. They are allowed to block if they are the subject of a court order, but they are not allowed to do so voluntarily. It's also important, and for my lord's note, the relevant provision is Article 3. As I say, it's on page 1281 of the electronic bundle. It's also important to understand that internet service providers have nothing to do with the content of the target websites which are the subject of this case. The purpose of the injunctions is to prevent the internet service providers' subscribers getting access to these third-party websites. But the websites themselves still exist, and they can continue to be accessed both through the services of other internet service providers in this country and in other jurisdictions. Now, against that background and introduction, I just want to outline briefly the core of my submissions to my lords this morning. First, I propose to spend a little bit of time identifying the general approach to costs of injunctions against innocent parties from the authorities. Secondly, I want to explain why we say that approach should apply here for the 3 reasons I've outlined. And in so doing, I will explain why we say the reasoning of the court below was wrong. Thirdly and lastly, I propose to address some policy points and to explain and address the Section 97A arguments raised by the interveners in this case.
Can I just ask you, in relation to the your statement that ISPs can't block voluntarily,
Yes.
I'm just looking at Article 3 on MS 1281, and I mean, I haven't looked at this until now, but it looks as though, although there's a right of end users to access, and providers under paragraph 3, providers of internet access services are required to treat all traffic equally and so forth. But in each case, that initial proposition is qualified. So, for example, 3 is qualified later on in subparagraph A, so far as necessary to comply with either union or national legislation.
Yes, so the bit we had in mind was under Article 3, it's the 3rd paragraph, providers of internet access services shall not engage in traffic management measures going beyond those set out in the 2nd subparagraph, and in particular shall not block, slow down, etc.
Yes, except,
and then paragraph A.
That's necessary.
yes, in order to comply with union legislative acts or national legislation that complies with union law.
Or as ordered by the court.
Yeah. So, I mean, if you were to interfere...
So where is this "or" is ordered by the...
It's in the last sentence of little a.
Oh, I see, including, yes, I see.
Yes.
So does that not enable you to block sites selling counterfeit goods, for example?
It does enable us to do so when we are ordered to do so, but it doesn't enable us to do so on a voluntary basis.
Well, why not? I'm not quite sure.
You say there's no legislation which requires you to block that? Is that the...
Exactly.
Yes, because you say you're not subject to the trademark rules because you're not infringing them.
Exactly.
Therefore, you don't have to block in order to comply with national legislation or union legislation in relation thereto.
Yes.
Yes.
You did mention that you were going to have to distinguish Section 97 cases, or at least explain the position. But for my part, I hope also that at some stage you're going to address the written submissions of the mobile network operators. That's Telefonica, Vodafone and Hutchison, who raise some concerns about the potential for expansion of the principle which you're relying on in relation to mobile telephone communications.
Yes.
You will do that.
Yes, my lord. So can I start then with the general principle which we say can be drawn out of the authorities?
Okay, I'm sorry. Just before I leave that point, are you saying that it's only? Are you saying that the absence of national legislation to which the provider of the internet access services is subject is something which applies to all breaches of intellectual property rights? And I'm just wondering, for example, here we're dealing with trademarks and the sale of counterfeit goods.
Yes.
But in a copyright case, the ISP would actually be providing the medium through which the infringing material is downloaded.
Yes.
Would you argue that in that situation as well, the ISP isn't actually subject to national or union law?
Yes, because the ISP equally isn't an infringer in that situation either.
Isn't it?
No. Because the internet service provider in that situation is not undertaking an act of communication to the public. That's the point. And the reason the internet service provider is not undertaking an active communication to the public is as follows. Firstly, as we'll come on and see, Recital 27 of the Information Society Directive expressly provides that the mere provision of a physical network doesn't amount to an act of communication to the public.
Recital
27 of the Information Society Services Directive. Secondly, as we see from the case law, in order to undertake an act of communication, the actor is required to have specific knowledge and to intervene in the act, which amounts to the communication. So they need to intervene in the act and have knowledge of what they're doing. It amounts to a communication of a copyright work. And of course, in the case of the internet service providers, that never happens because of the obligation upon them not to monitor the content of the information that they transmit. They're not allowed to monitor the content of the information that they transmit, and they don't do so. Indeed, it can be a criminal offence to open up the packages of information and consider what they look like. And so all that the Information Society Service Provider does is transmit closed packages of information from one party to another. They themselves never have the knowledge, the requisite knowledge of the content of those packages to put themselves in the position of a party who is undertaking an act of communicating to the public.
Yeah, so you distinguish the European case on the basis that there the software or whatever it was specifically designed to do
Indeed, that's the film.
the job of
Yes.
effectively.
Yes, that was the film Spieler case.
Yeah. Yes.
And that internet service provider, or that provider had gone one step further and had deliberately put software onto the kit to provide access.
Facilitate infringement.
Indeed,
Yeah.
a direct facilitation.
Yeah. Right, we'll carry on. We've got quite a lot to get through, I think.
We do. I'll be as quick as I can. Principles.
Well, you'll be very clear in your case on this first point, I think. So perhaps you can take it possibly by reference to your case or a bit shorter. But anyway, let's have it.
Thank you. Well, I'll be guided by my lords. We say that the authorities establish that where an innocent party gets mixed up in the wrongdoing of another in a way that facilitates that wrongdoing, they come under an equitable duty to assist the victim of the wrong. The duty is manifested in the form of the injunction against the innocent party, and one of the conditions of that injunction is that the applicant must indemnify the innocent party of the costs and expenses reasonably incurred. And we see this principle invoked in cases such as Norwich Pharmacal and Bankers Trust, but we also see the same approach to costs in other types of cases which are not about disclosure, such as Miller Brewing, which are not based on the equitable protective duty, such as Morava, and in cases where common law powers have been developed to require innocent parties to assist, such as in Singularis. Since the respondents don't challenge the principle itself, and in light of my Lord's observations, I'll deal with this as quickly as I can, but I just wanted to draw out a few relevant passages from some of the authorities. If we could first look at Norwich Pharmacal, please, which is in Volume 1B, tab 15, page 739 of the electronic bundle.
Which tab number, please?
It's tab 15.
Thank you.
And I just wanted to take my lord firstly to the statement of principle from Lord Justice Buckley, which my lords find at the very bottom of page 751. At H, second sentence. If a man has in his possession or control goods the dissemination of which, whether in way of trade or possibly merely by way of gifts, will infringe another's patent or trademark, he becomes, as soon as he is aware of this fact, subject to a duty, an equitable duty, not to allow those goods to pass out of his possession or control at any rate in circumstances in which the proprietor of the patent or mark might be injured by infringement ensuing. It goes on to say this duty is one which will, if necessary, be enforced in equity by way of injunction. The man having possession or control may be under a duty to give information in relation to the goods to the proprietor of the patent or mark. And just to note there, firstly, the duty only arises on knowledge.
The duty is therefore related as being a duty not to allow goods to pass out of his possession or to give information.
Indeed.
Are you submitting that these are essentially illustrations of a broader principle, that is the duty of general assistance in equity?
Indeed.
Where do we get that from?
Where do we get the broader duty?
Broader duty.
Well, we see a number of different examples of that duty in the cases that we've cited in our written case, such as, for example, Miller Brewing, which is a duty of delivery up, and we see it in Singularis. Well, that was a common law power, but by reference to an analogy with Norwich Pharmacal in accordance with the duty to assist imposed on in respect of the foreign liquidation.
Well, is a general principle expressed in any of these cases? I mean, you say that these are illustrations of the principle, but is there an enunciation or articulation of the principle in any of the cases?
Well, I'm taking my lord through the authorities.
Right, okay.
And I'll show you.
Okay.
Well, I suppose Mr. Justice Newberger, as he was in Miller Brewing, comes close to enunciating a general principle.
So I'm going to take my lords there. But can I first show my lords what Lord Reid says on page 781 of the bundle? Perhaps I could just ask my lords to read the paragraph that starts just below A, down to the bottom of C.
Bottom of A.
Bottom
C.
of C. So just the full paragraph that starts, my noble and learned friend.
It finishes with perpetration.
Indeed. Thank you, my lord.
Maybe that Altman and Elkan is where we should look for the general principle.
Yes, you would say that is the overarching principle articulated by Lord Reid.
That is the principle expressed, isn't it?
It is. Yes, indeed. Indeed. And not only is it a principle of the duty, but it's a principle in respect of the cost consequences in the exercise of that duty on behalf of the innocent party. If it causes him expense, the person seeking the information in this case, or in respect to the innocent party exercising the duty, the applicant ought to reimburse him. And we see the same sentiment over the page in respect of costs. So this is in bundle page 782, between C and E. In the third sentence of just below C, if the respondents have any doubts in future cases about the propriety of making disclosures, they are well entitled to require the matter to be submitted to the court at the expense of the person seeking the disclosure. And Lord Reid goes on to say, at D, the respondents were quite right in requiring the matter to be submitted to the court. They are entitled to their costs down to the date of the judgment of Mr. Justice Graham. Thereafter, they the appellants caused much extra expense by putting their case much too high. In the circumstances, I would award no costs in the Court of Appeal or in this House. And we see the same approach to costs taken by Lord Cross. This is on page 805. And we can pick it up just below E, in the middle between E and F, after the semicolon on the right-hand side. In any case in which there was the least doubt as to whether disclosure should be made, the person to whom the request was made would be fully justified in saying that he would only make it under the order of the court. And then at the bottom, full costs of the respondent of the application and any expense incurred in providing the information would have to be borne by the applicant. And the other lords agreed with this approach on costs. We say under the formulation of the duty, it's clear that a party can facilitate a wrong while still remaining innocent and recovering its costs. It's also clear that knowledge of the wrong doesn't remove innocence. To the contrary, knowledge is a prerequisite before the duty will be imposed upon the innocent party. The next authority we wanted to remind my lords of, and upon which we place reliance, is the totalised decision. My lords find that in volume 1B, tab 19, and it's also addressed in our written case at page 77. And it may be more convenient to take it from our written case.
Yes.
We rely in particular on paragraphs 19 to 31 of this decision. And we set out paragraph 31 in our written case. And paragraph 30, sorry, in our written case. And we draw out the following points from that paragraph. Firstly, we say it's clear that the general rule is that the applicant should bear the reasonable costs of compliance and the legal costs incurred by the innocent party. Secondly, it's clear that the rule applies just as much to an online service provider who was the third party in the totalised case as to any other kind of innocent party. Thirdly, we rely in particular on the analysis set out by Lord Justice Aldous in respect of the approach to legal costs as well as compliance costs in this paragraph, because we say that all 5 of those factors that Lord Justice Aldous identified apply with equal force in this case. This was just as much a case where it was right to bring the matter to court, where the internet service providers had a genuine doubt as to whether or not it was appropriate to make the orders, and they were not able to submit to them voluntarily and could well have been on the wrong end of proceedings with respect to subscribers without a court order.
But does this decision, in conjunction with the present case as decided below, mean that if you were asking an internet service provider to give you information about an infringing website,
Yes.
then the internet service provider would get an indemnity as to the costs of providing the information. But if you were asking them to block the infringing website, then the internet service provider wouldn't get an indemnity.
That is the consequence of the current situation. So the normal Norwich Pharmacal principles apply equally to internet service providers as they do to any other kind of innocent party. We see that in Totalize. We also see that in the GoldenEye case that we also cite in our written case. It's one of the reasons why we say the judgment of the court below is wrong in principle, because there's no logical reason to treat the internet service providers any differently in this case, in the context of a blocking injunction, as there is in the Norwich Pharmacal or other kind of situation where an innocent party is subject to a compulsion order in accordance with a duty to assist. The next authority I just wanted to draw to my Lord's attention was Miller Brewing. This is in bundle 1A, tab 14. It's page 723 of the electronic bundle. This was a decision of Mr. Justice Newberg, as he then was. It concerned counterfeit beer. There had been an order for delivery up of the beer, and the claimant trademark proprietor accepted that the docking company should be reimbursed and indemnified in respect of the costs of implementing the order. And in that respect, Mr. Justice Newberger said that the claimant was plainly right to accept that they were subject to compliance costs. The issue in that case was legal costs, and the relevant paragraphs for my Lords are paragraphs 28 to 31, which my Lords find on page 730 of the bundle. And perhaps I could just ask my Lords to read paragraphs 28 to 31.
Yes.
Thank you, my Lords. We draw out 3 points from those passages. First, these passages confirm the principle that it is the applicant and not the innocent party who should normally have to bear the costs, regardless of whether the relief is based on the equitable protective jurisdiction or is rooted in statute. Second, this case demonstrates a broader application of the cost principles recognised in Norwich Pharmacal, this time to the statutory claim of delivery up. And this is an answer to the respondents' point in their case that the cost approach is limited to equitable bills of discovery. It's clearly not. Third, we rely on the logic of the principle as enunciated by Mr. Justice Newberger, namely that as between the innocent party and the applicant, it is far more unjust for the innocent party to have to bear the costs of the relief than it is for the applicant. In our written case, we try and give a range of examples of different types of scenarios where innocent parties have been subject to injunctions. Some of the examples are based on the equitable protective duty, either in the form of disclosure or delivery up. Some examples are based on a more general principle in relation to costs applied in other cases involving innocent parties, for example, Moreover. As my Lords will know, a Moreover injunction is obviously based on the court's inherent powers. It's now given statutory force under Section 37(3) of the Senior Courts Act. It's based on a claim to protect identifiable property rights. It isn't based on the equitable protective duty. And whenever an applicant seeks a Moreover, they are required to give an undertaking to pay the reasonable costs of anyone other than the respondent who is going to incur costs in respect of the implementation of that injunction. Another example we rely on in our written case is Singularis, and it is worth spending a moment just looking at that decision. My lords find it in Bundle B, 1B, tab 16. It's page 814 of the electronic bundle. Now, as my lords will recall, the issue in this case was whether there was a common law power to assist the liquidators of the Foreign Court of Insolvency jurisdiction by ordering the production of information necessary for the foreign winding up. And the majority held that the power existed, and my Lord Sumption drew an analogy with Norwich Pharmacal to explain why the common law could be developed in this way. And consistent with that, my Lord recognised that the power should be subject to the equivalent conditions in respect of costs. And we see this at paragraph 21 on page 834, going down to the start of paragraph 23 on 835. So my Lord Sumption in paragraph 22 recognises the existence of a duty to provide information in certain circumstances. The duty of a person who has become involved in another's wrongdoing was held to be to assist the person who has been wronged by giving him full information and disclosing the identity of the wrongdoers. It's clear that this duty is of a notional kind. It's not a legal duty in the ordinary sense. Failure to supply the information wouldn't give rise to an action of damages. The concept of the duty is simply a way of saying that the court would require disclosure. And my Lord, at paragraph 25, having recognised the existence of common law power in this case, identifies the conditions which will apply to the exercise of that power. And for our purposes, the relevant provision is the last sentence at the end of paragraph 25, which my Lords find on 837, where my Lord Sumption recognises that, as with other powers of compulsion exercisable against an innocent third party, its exercise is conditional on the applicant being prepared to pay the third party's reasonable costs of compliance. And my Lord Mance was in agreement with that aspect with the same cost principle, and we see that at paragraph 121 on page 857, where my Lord observes in this paragraph that the joint official liquidators, that PwC had asked for an undertaking in respect of costs or other liabilities which might arise from complying with the order, and the Court of Appeal declined to make the order or require any undertaking in the absence of authority. And as my Lord observes at the top of page 858, that the absence of authority wasn't surprising, bearing in mind that the order itself was unprecedented, but my Lord observed that the costs of compliance were likely to be substantial, and whether or not they were or could be quantified when the order was made, PwC should have been protected in respect of them. Common justice and established practice relating to freezing injunctions, Anton Pillar orders, and Norwich Pharmacal relief should have confirmed the need for an appropriate order or undertaking in that respect.
Well, I have a pretty clear recollection that Lord Sumption and I had to eat humble pie on the spot. There's a later judgment in this case, and Pricewaterhouse didn't actually get their costs for reasons which are set out in it. I think
That's also my recollection, but I can't quite remember where it's...
A little bit of research by your juniors will turn it up. I'm just looking at the Privy Council website, but it's, I gave the judgment, I think, at least one of them. It may have been, may or may not have been still singularis. It was probably Price Waterhouse, yes.
We'll try and find it. I'm sorry I wasn't aware of that later.
No, I'm sure you won't. But we did eat a little bit of humble pie on those statements.
But without knowing the reasons why a different cost order was made in the end, that doesn't distract.
No, I don't think. I don't think you'll find that it troubles your primary submission.
No, it doesn't detract from the principle, which both of my lords recognise in the authority that I've taken you to, which is a principle in respect of any innocent party who's subject to an order of compulsion to assist. That innocent party should be indemnified in respect of the costs and expenses in carrying out that order. For completeness, in the singularis decision that I've taken my lords to, both my Lord Mance and Lord Neuberger warned about new developments of common law powers and said that any development should be approached with caution. And we respectfully submit that the same caution applies in this case, where having recognised the power to exercise its jurisdiction in a new way, the court should be very careful to apply established conditions and principles from the existing case law.
I think you'll find that the supplementary judgment is Price Waterhouse against Saab and singularity against Price Waterhouse, and it is 2016 UKPC 33 and heard 17th November, and I gave the judgment supplementary to that given on the 10th of November 2014. The decision, the issue now concerns the costs incurred by PwC, etc. And as I say, I'm afraid they didn't get their costs, but you'll have to look at the reasoning.
We'll have a look at the reasoning over lunch, my lord.
But I don't see that it really focuses on the present point. But you'll have to decide that between you.
Thank you, my lord. So I wasn't proposing to spend any more on the authorities in relation to the principle that we rely on. I want to now move on and explain why we say that principle should be applied in this case. Our primary position is that the same principle of indemnifying innocent parties against costs should apply in this case because of the fundamental features in common between this case and the authorities that we've been looking at. This case, just as the others, involves an order in the form of a power of compulsion. It's an order against an innocent party. It's a party in respect of which there is no legal duty owed to the applicant, which can sound in damages. Instead, the duty is owed to the court and arises when the injunction is made or granted. As I say, the duty is crystallised in the injunction itself, and it requires the internet service provider to take steps to assist. Those steps to assist are in particular the protection of the respondents' private property rights, and it's recognised that they should do so in the interest of justice. And we say that any blocking injunction against an internet service provider ought to follow the same approach to costs as has been applied in those other cases as against other innocent parties. We also submit that this view is reinforced by the analogy with the equitable protective duty, which was relied on by the Court of Appeal to justify the exercise of the power to grant the injunction in this case. And as a matter of logic, the courts should have applied the same analogy when it came to costs. And we see the analogy in the judgment of the Court of Appeal, which is in the core bundle at page 198. And the bit we're interested in is in the section where Lord Justice Kitchen is dealing with a question of jurisdiction, it starts at paragraph 33, but we can pick it up at paragraph 51, which is on page 221. So after the judge had gone through some of the relevant authorities in relation to the question of jurisdiction, finishing up with Furey and LaRue, he went on at paragraph 51 to draw an analogy with the equitable protective duty as described by Lord Justice Buckley in Norwich Pharmaceuticals we've seen this morning. And at paragraph 52, he explained that whilst Lord Justice Buckley's formulation of the duty is not directly applicable, because of course in this case the internet service providers don't have physical possession themselves of any infringing goods. Nevertheless, he agreed with the judge below that it wasn't a long step to conclude that the internet service providers were subject to a duty to take steps to assist the person wronged by infringements once they are aware that their services are being used by third parties to infringe. So the judge identified and imposed upon the internet service providers a duty to assist, a duty which he recognised by analogy with the duty in Norwich Pharmaceuticals. He also, at 53, goes on to rely on Lord Reed's formulation of that duty.
Yes, which we read, yeah.
Then at paragraph 54, he confirms that the internet service providers are innocent, they are not guilty of any wrongdoing. He rejects the argument that injunctions are limited to particular situations and holds that injunctions can be recognised in new categories in accordance with equitable principles. At 55 to 56, he comes on to identify the particular equitable principles that he relies upon to justify why the court should exercise its inherent power in a new way in this case. 3 reasons are set out in paragraph 55. The first is the reason that it's not a requirement to grant an injunction against a wrongdoer. Second reason is that because of the breadth of power, the breadth of the inherent power, the court can exercise it in new ways. And the third reason was by way of a recognition of the duty, by way of analogy, imposed upon the ISPs. At paragraph 56, he went on to recognise what he described as a further and important consideration, which was the effect of Article 11. So he recognised that it was consistent with the inherent jurisdiction of the court to exercise that jurisdiction in a manner that was consistent with Article 11, as well as in a manner that was consistent with the duty he had imposed on the internet service providers by analogy with Norwich Pharmaceuticals. We see reference to that analogy again at paragraph 138 on page 244. Paragraph 138 on page 244, where the judge records my submission and he accepts that the issue of jurisdiction, the judge drew an analogy, as would I, with the equitable protective duty described in Norwich Pharmaceuticals. And again at 148, para 148, on page 246, Justice Kitchen records the judge drew, this is the second sentence, the judge drew what I considered to be an entirely appropriate analogy with the Norwich Pharmaceuticals jurisdiction, but its foundations, whether considering the equitable protective jurisdiction or disclosure jurisdiction, are rather different from those of website blocking orders. Lastly, in respect of Lord Justice Briggs' decision, he also relies on the analogy So his reasoning starts on page 257, and it's actually the whole of the passage set out between paragraph 200 and 205. Between 200 and 204, the judge identifies by reference to authority the existence of a duty to assist imposed on an innocent party who's been mixed up in the wrongdoing of another, in circumstances where that innocent party facilitates the wrongdoing. And the duty, as I say, is a duty to assist the victim of the wrongdoing.
Is there a distinction between the two types of Norwich pharmacal duty discussed by Lord Justice Buckley and in the House of Lords? Lord Justice Buckley seems to be talking about, or using the analogy of situations where you're physically in possession of goods,
yes,
and you mustn't part with them, whereas the House of Lords is talking about situations where you're in possession of information and
yes,
you must disclose it if ordered. In the present case, we're sort of,
it's
draw
withholding
an analogy with
information.
either, but you can say it's rather similar to the first in the sense that you're not actually physically in possession, but you are of the information, but you are physically, or at least you're in through software, in possession of the key to access to the website.
One could think about it as withholding the information rather than disclosing the information.
Yes.
But yes.
But I mean, is there a relevant distinction for
No,
present purposes?
for our purposes, not at all.
No.
And my lords might have noticed when we looked at Norwich Pharmacal, both Lord Justice Buckley and Lord Reid rely on the same underlying authority, the Upman and Elkin decision. So they are just different manifestations of the same underlying principle,
Yeah.
which pertains to a duty to assist on behalf of the innocent party when they are mixed up in the wrongdoing. And whether that duty manifests itself in the form of providing disclosure or providing information, blocking access to information, or delivering up infringing goods, it doesn't matter. That's just the particular formulation of the specific nature of assistance. What matters for our purposes is the duty itself. And as my Lord Sumption recognised in Singularis, that duty is of a rather notional kind. It's not a duty owed directly to the respondent. It's a duty which manifests itself in the form of the order, and it's a duty which is owed to the court.
Well, the point I think I would make is it's not a duty that exists in the absence of the order.
Indeed. Just to finish the analysis of Justice Briggs's reasoning, at paragraph 205, having drawn out the threads and the principles from the case, he says, like both the judge and my lord, I consider that the reason why the courts of England and Wales have jurisdiction to make blocking orders of the relevant type is that they are indeed a natural development of the court's enforcement of the equitable duty to assist. And at the end he says, it was a jurisdiction with existing well-recognised conditions or modalities, one of which was that the victim indemnify the innocent party for its costs of complying with the court's order. And of course we say that's absolutely right.
Yes, but if the duty doesn't exist in the absence of the order, how is the court enforcing a pre-existing duty, as Lord Justice Briggs suggests in paragraph 205? I mean, there's a danger of allowing judicial rhetoric, I think, to mislead. Because the duty doesn't exist absent the order, you accept that.
Right.
So how is
Justice Buckley's duty does exist, I would have thought, absent the order. He's saying, relying on Alman and so on, there's a duty not to part with infringing goods.
Once you know they're infringing.
Once you know, so it's a bit odd. I mean,
The point that was being made in Singularis, this isn't the kind of duty which you could sue on in an action for damages. It is simply the basis on which one's entitled to obtain, on the right facts, an order.
Yes. I don't understand, my Lord Justice Briggs, in paragraph 205, to be saying that the duty is a pre-existing duty. I think it's just a recognition of a principled basis to exercise the inherent powers of the court to impose an injunction on the ISPs in recognition of the duty to assist, which itself manifests in the form of the injunction.
Thank you.
I share Lord Hodges' puzzlement. I thought when we looked at Article 3 of the directive you first took us to, your position was that there is no duty on the ISP to do anything about infringing material. Are you suggesting now that there is some duty?
No. What I'm trying to do is identify the reasons given by the court below to justify the inherent power to grant the injunction. And the court was trying to identify a principled basis upon which to exercise that inherent power. And one of the principles that it articulated was that it was consistent with a recognition of a duty of any innocent party mixed up in a wrongdoing to assist, but the duty doesn't arise in advance of the injunction itself, because it's not until the ISP is put on notice of the application that they have any knowledge of the existence of the wrongdoing.
That may be the case, but not necessarily. What Lord Morris seems to have been saying in Norwich Farm was that it was an equitable principle which entitled the court to bring such a duty into existence by making an order. And it was because of that, that was part of the reason why it had to be at the costs of the person seeking the order, because there was no breach of duty in having failed to do it before the order was applied for.
Indeed. And so too here, there's no suggestion of any breach of duty on the part of the ISPs before the order is applied for in this case. Now, in respect of...
I don't know how important this is, but going back to the authority of Upman and Elkin, on which the House of Lords relied in Norwich Pharmacal,
Yes.
The proposition there appears to be that as soon as Messrs. Elkin, who had the misfortune to be importers of infringing goods without realising that their consignors were fraudulent. Anyway, they were innocent importers, but as soon as they were told of the fraud, it was their duty to give the property owners, the owners of the trademarks or copyright or whatever it was, the information as to the identity of the consignors for which they were asking, and to undertake that the goods should not be taken from the warehouse until the spurious brand had been removed. So that sounds like a duty which arises independently, prior to the court order, from the knowledge.
It sounds like a classic equitable duty arising from the effects of the knowledge upon the conscience of the party.
Yes.
Is that good enough for your purpose? Why are you emphasising that the duty only arises on court order?
Well, it is a distinction, but in relation to the nature of the duty imposed on the ISP from the duty in respect of the Upman and Elkin case.
It doesn't actually make any difference to the outcome of the present case.
No.
I presume that the reason why you're referring to it is simply that the majority in Singularis and in Norwich Pharmacal proposition seems to have been accepted by Cross and I think at least one other member of Norwich Pharmacal. That was what they said.
Yes.
But I don't, whether they were right to do so isn't a question that affects your argument. I understand it.
That's absolutely right, my Lord. Lord Justice Kitchen, in his judgment, at paragraph 148, identified two alleged points of difference, which he said differentiated this case from the Norwich Pharmacal analogy, and which he relied upon to justify, at least in part, taking a different approach to costs. One reason he gave in paragraph 148, that's on page 246 of the bundle, was that these proceedings are not preparatory to proceedings against a wrongdoer. And the second reason he gave was that there was no real prospect in this case of recovering costs against the wrongdoer. Now, we addressed this in our written case at paragraph 110.
Neither of those factual situations is inevitable. They seem very likely to be the case in most cases, but they're not a exercise.
Indeed. In fact, we would say that we don't accept that it's a unifying attribute of the cases we've been looking at, that they are preparatory to other proceedings.
Why
should that matter anyway?
It doesn't matter anyway.
No, to your case, it doesn't matter.
It doesn't matter anyway, but I've obviously got to address it because there's a reason given by Lord Justice Kitchen.
Well, the reason they're not preparatory to other proceedings is that the assistance is itself effective.
Indeed.
The blocking means the other proceedings are nugatory. If you have that type of assistance, the question of other proceedings just doesn't arise.
Well, it may or may not, and that's obviously a matter for the trademark.
Not
operator.
100% effective, I think the evidence is.
Yes.
Though it's effective in a sufficient number of cases to make it work.
Yes.
Indeed. It's obviously.
But I mean, the only relevance of it is it said, well, in Norwich Pharmacal, it doesn't matter who pays the costs because ultimately they come out of the pocket of the wrongdoer. Whereas in practice, that's not going to be the case in at least a high proportion of the sort of cases we're considering here.
Absolutely.
There's
And it's
no inevitability about that.
No, indeed.
Not necessarily true.
Indeed. And our point is it's certainly not a prerequisite of getting Norwich Pharmacal type relief that the applicant to that kind of relief is then going to go on and pursue the wrongdoer. And indeed, there's a clear statement to that effect by my Lord Kerr in the Viagogo decision, which is in bundle 1B, tab 18,
The ticket offence.
page 886. And there it's nothing more than a very clear statement to the principal that it's not necessary for an applicant to intend to bring legal proceedings in order to get the relief. This is paragraph 15, page 886. Now, of course, in this case, it's a matter of choice for the trademark proprietors, for the respondents, as to whether or not they go on and pursue the actual wrongdoers, the people who are behind the websites.
But you say they could, if they bear the costs, contrary to the Court of Appeal, they could actually pass the costs on, whereas your clients presumably would have considerable difficulty in passing the costs on to the wrongdoers because they don't have any relationship
Indeed,
with them.
my clients have absolutely no opportunity at all to recover the costs as against the wrongdoers. It's a matter of choice for the trademark proprietor whether they do so or not. They may face practical difficulties, but they certainly have the opportunity to seek those costs as against the wrongdoer. And of course, we also rely on the fairness points, which I drew my Lord's attention to coming out of the Miller Brewing case. As between the innocent internet service provider and the innocent trademark proprietor, it's much more unjust for the innocent internet service provider to bear the costs in circumstances where he's called on to assist through no fault of his own, whereas at least the trademark proprietor is getting the benefit of the injunction and has the opportunity to seek those costs where they ultimately fall, namely as against the wrongdoer. Now, the respondents attempt to identify some alleged differences between a Norwich Pharmacal kind of order for disclosure and the injunctions in this case, in part of their criticism of our reliance on the analogy. We say the distinctions that are drawn are completely without merit. I don't propose to go through them all, but just by way of example, one of their arguments is that blocking is about preventing future wrongdoing, whereas Norwich Pharmacal is about redress for the past. Of course, that's completely incorrect. We see it in a number of cases in the Norwich Pharmacal sphere where the relief is granted in order to protect against future wrongdoing. Take, for example, the Ashworth case, where it was all about preventing future leaks of patient information from that hospital.
What's the reference to Ashworth?
Ashworth, my lords, is in bundle 2, tab 44,
Yeah.
page 1345.
Yep.
Can you identify the paragraph?
Yes, I'm sorry.
Well, if you can tell us what it says in summary, we can probably find it.
Yes. So the paragraph, in the decision of Lord Slim at paragraph 3, makes it clear that it's not necessary, it's not a precondition of the exercise of the jurisdiction that the applicant had the intention to begin or had begun legal proceedings. And we see the same statement at paragraph 47. And I'm afraid I can't lay my finger on the relevant paragraph, but what's clear from this case is that what was of most concern to the hospital was the source of the leak, so that they could take steps to stop further leaks. Perhaps over lunch we can identify the relevant paragraph and tell my lords this afternoon. So, my lords, the other reasons that Lord Justice Kitchen identified in support of his approach to costs were EU law reasons. And so it's to EU law that I would now like to turn. The reasons that Lord Justice Kitchen gave are at paragraphs 143 to 147 of his judgment, and I can summarise them as follows. First, he said a different costs approach should apply because of the immunities available under the e-commerce directive. Second, because internet service providers profit from the services they provide, and that supports the view that they should pay for the cost of the injunction as part of the cost of carrying on business. Third, he said it was implicit in EU legislation. And fourth, he said his approach to costs was supported by the Court of Justice case law. Now, those reasons are exactly the same reasons that Mr. Justice Arnold gave at first instance, and they're also the same reasons that Mr. Justice Arnold gave in the News Bin 2 case, which was the first case under Section 97A on costs, and which has been applied in all copyright blocking injunction cases going forward. Now, we submit all of these reasons are wrong, as I shall explain, and that actually it's clear that EU legislation leaves the question of costs to national law. And that's a further reason we say why the general equitable principles apply to the costs of the injunctions in this case. Let me start by showing my lords the enforcement directive, which is in bundle 1A, tab 5. This is dated April 2004. It pertains to enforcement of intellectual property rights. It's page 475 of the electronic bundle. The purpose of this directive is to ensure intellectual property rights enjoy equivalent levels of protection throughout the community, thereby removing disparities which might otherwise weaken substantive law and lead to fragmentation of the market. It concerns a number of measures, procedures, and remedies available to achieve this objective. What we're interested in is Article 11, which my lords find on page 482. On the left-hand side, Article 11, headed injunctions. Perhaps I could just ask my lords to read that. It's the second half that we are particularly interested in. The bit that says, Member States shall also ensure that right holders are in a position to apply for an injunction against intermediaries whose services are used by a third party to infringe an intellectual property right without prejudice to Article 8.3 of the Directive 2001/229 EC, which is the Information Society Directive. Now, Article 11 must be read in conjunction with Recital 23. This provides that, this is on page 477, without prejudice to any other measures, procedures, and remedies available, rights holders should have the possibility of applying for an injunction against an intermediary whose services are being used by a third party to infringe the right holder's industrial property right. The conditions and procedures relating to such injunctions should be left to the national law of the member states. That sentence is very important. Because it's that sentence which makes clear that conditions and procedures, including costs, pertaining to injunctions against intermediaries are a matter of national law. Contrast by way of example, the next recital, Recital 24, which provides that depending on the particular case and if justified by the circumstances, measures, procedures and remedies should be provided for should include prohibitory measures aimed at preventing further infringements of intellectual property rights. So that's prohibitory measures aimed at the infringer. Moreover, there should be corrective measures where appropriate at the expense of the infringer. And that's reflected in the language of Article 10.2, which we see on page 482. There it provides the judicial authority shall order that those measures be carried out at the expense of the infringer unless particular reasons are invoked for not doing so. We see a similar reference to expense at Article 15 on page 483. This relates to publication of judicial decisions, and it provides on the third line, this will also be at the expense of the infringer. Now, of course, Article 10 and Article 15 aren't relevant for the purposes of our case, but the point here is to demonstrate that where the directive wants to provide for the allocation of expense, it does so expressly. Just whilst we're in this directive, the other point of interest is Article 8. This provides for a right of information. Of course, Article 8 wasn't implemented in any way in this jurisdiction because we already have Norwich Pharmacal Relief. But Article 8 also says nothing at all about costs, and the English courts continue to apply the established national law approach to costs in respect of respondents who are the subject of Norwich Pharmacal kind of relief, including internet intermediaries, as we've already discussed this morning. Finally, I should refer my lords to Article 2, and in particular Article 2, subparagraph 3, little a, on page 478. And this sets out that the directive shall not affect, and it lists a number of different directives, the last of which is Articles 12 to 15 of the e-commerce directive. That reinforces our view that there is no reciprocal package as between this directive, the Enforcement Directive and the E-Commerce Directive. To the contrary, one is expressly provided as not affecting the other. Now, it's important to recognise the ambit of the Enforcement Directive. It's limited to intellectual property only, but it applies to all types of intermediary. That's both online intermediaries and offline intermediaries. And we see that clearly from the Tommy Hilfiger decision, which we referred to in our report. That's a decision of the Court of Justice in which the court interprets the meaning of intermediary under Article 11 and holds that it applies not just to electronic commerce and online intermediaries, but also to offline operators. In that case, the offline operator was a market stall provider in Prague, in Czechoslovakia, and that market stall provider was the subject of an injunction under Article 11 because they had got mixed up in wrongdoing because individuals who rented stalls in the market were selling counterfeit goods. For my Lord's note, I don't think we need to go to it, but the reference is Volume 1B, tab 31, page 1107, and the relevant...
Relief obtained, the provision of information or the cessation of the provision of stalls to those people.
I'm sorry, I didn't...
What was the relief obtained? The provision of information, or was it not providing stalls to infringers?
It was actually a little bit more sophisticated than that. It required various contractual obligations on the part of the market stall provider on the one hand and the tenants on the other, including a contractual restriction that the tenants wouldn't supply counterfeit goods and such like.
Basically required for the future that they were to insert such provisions in their contracts.
Indeed, yes.
And I presume by implication enforce them.
I'm sorry?
And enforce them, I presume.
Yes. The next EU provision to look at is the E-Commerce Directive. This is in tab 4 of Bundle 1A, page 459. Now, the purpose of this directive is to encourage the development of e-commerce as an information society service. And the point is to remove disparities between member states that hamper the development of the information society. What we're interested in is Articles 12 to 15, which my Lords find on page 470. These are the immunities, or the so-called safe harbours, which my Lords will have seen referred to in the written cases. The first thing to draw to my Lord's attention is that these safe harbours only apply to online service providers. They do not apply to offline activities. And this is because they all relate to what's described as an information society service. My Lords will see that in the opening of each of Articles 12, 13, 14. And if my Lords flick back to recitals 17 and 18, this is where the directive explains what an information society service is. It relies on the definition provided in Article 1 of Directive 98/34 EC, which for my Lord's note, we don't need to go there, but that's in Bundle 5, tab 77, electronic page 2084. And just to paraphrase, an information society service is one provided for remuneration at a distance using electronic equipment at the request of the recipient. And recital 18 makes clear that information society services relate to online activity, but we can see on the third line, activities such as the delivery of goods as such, or the provision of services offline are not covered. The other thing, just flicking back to Articles 12
Being referred to volume 5.
to 14.
You've got 1 to 4.
So, my lords, have the first point. These safe harbours are limited to online only. The other thing to notice, though, is that they are not limited just to intellectual property. They relate to all types of wrongdoing.
Ms. May, did you say that directive was in volume 5?
Yes, so it was originally in one of the other volumes, but we realised that the incorrect version of the directive had been included, not the updated version. So we produced a new thin bundle with the correct one in it, in case my lords needed to see it.
Right.
I can hand one up if my lord doesn't
Yes,
have
I'm not sure we have a volume 5.
I'm told that my lords may only have it electronically, but I can provide a physical copy. Because the particular definition of information society services was inserted by amendment, and unfortunately only the original directive was in the original bundles. This is the amended version of the directive, and it's on page 2084.
We've got it electronically,
Yes.
some of us.
Some of you.
So, my lords, turning back to the safe harbours, Article 12 is the one that we're interested in the sense that this would be the one that would apply to the internet service providers if they were otherwise liable for a wrongdoing. But of course, in this case, they are not liable for a wrongdoing, and the reason they're not so liable is because they don't fall within Section 10 of the Trademarks Act, and in particular, they are not using a trademark in the course of trade. It's interesting to contrast Article 12.1 with Article 14.1.
Where do we find the Trademarks Act?
My lords find that in Bundle 1A, tab 3, and Section 10 is on page 445.
Yep.
Article 12 of the e-commerce directive, as I say, is the one that would apply to a mere conduit like the ISPs if they were otherwise liable. And the conditions are provided in subparagraph 1, A, B, and C. Those conditions are different from the conditions imposed upon a host or a platform, which my lords see in respect of Article 14. And the reason this is relevant is because it explains why platforms such as YouTube and eBay have this voluntary notice and takedown procedure. As my lords will see in Article 14, as soon as a host has knowledge of a wrongdoing, they are required to act expeditiously to remove the information. That's 14 sub 1 sub B. And so in the context of a host or a platform, they only get the benefits of the immunity.
All right, 14 sub 1.
1 sub B on page 471. They only get the benefits of the immunity if they immediately take down the offending information once they are put on notice of it. And so all the efforts in the respondent's case to try and shoehorn the internet service providers into the same situation as the platforms and hosts is completely misguided because the voluntary notice and takedown provisions of platforms pertains to Article 14, but the same conditions don't relate to Article 12.
So they're not voluntary, they're effectively compulsory because they are conditions of the application of the immunity.
They're voluntary in the sense they do them without a court order and they don't seek reimbursement from anyone.
Well, yes, they're voluntary in the sense that they could, if they didn't care about the immunities.
Yes.
Simply go ahead.
Yes, but then they'd be sued. They may or may not be sued. It would depend on the type of the wrongdoing. But lastly, in this directive, I need to draw my Lord's attention to Article 12, subparagraph 3, which provides that this article shall not affect the possibility for the court, in accordance with member states' legal systems, of requiring the service provider to terminate or prevent an infringement. So this Article 12, subparagraph 3, says in terms that nothing about the immunity under Article 12 has anything to do with the availability of an injunction against an intermediary. And that just reinforces the fact that there is no reciprocal relationship between the safe harbours on the one hand and the availability for an injunction against an intermediary on the other. Nor could there be when one looks at the legislative history of all of this. The enforcement directive came out nearly 4 years after the e-commerce directive. So the e-commerce directive is June 2000. The enforcement directive wasn't until April 2004. So the idea that one of them is a quid pro quo for the other just doesn't stand up. Lastly, my lords, the Information Society Directive. This is in tab 6. And we don't need to spend a lot of time on this, but the relevant provisions for my lords are Article 8(3), which is in similar terms to Article 11, but is specific to copyright. That's on page 493. And then recital 59, which is the equivalent recital, and that's on page 490.
Article 8.
Article 8(3.
Recital which?
Recital 59, and in particular the end of the recital, which provides that the conditions and modalities relating to such injunctions, that's injunctions against intermediaries, should be left to the national law of the member states. We say the language of the enforcement directive, and so too the Information Society Directive, is clear. Conditions and procedures relating to injunctions against intermediaries is a matter of national law. That's reinforced by the structure of these directives. The availability of the injunction against the intermediary doesn't affect the application of the safe harbours, and vice versa. That's expressed in the directives we've looked at. There is no integrated package, and nor can there be, because the safe harbours under the e-commerce directive only apply to online information society service providers, whereas Article 11 extends to all intermediaries, online and offline. Similarly, offline intermediaries cannot take the benefit of the safe harbours. Now, the respondents attempt to answer this point by saying that different circumstances should apply to online and offline intermediaries, and that somehow this justifies a different approach to costs in each case. But we say there is simply no principled basis for having multiple cost rules for different types of intermediaries, all falling within Article 11. If there were different rules for online and offline intermediaries, that would just reinforce the view that there cannot be an implicit assumption in EU law to the effect that the intermediary should always pay. So that's why we say the Court of Appeal was wrong not to apply the established principle of national law and recognising the authorities we've looked at this morning, which is that the ISPs, as innocent parties, should have been indemnified against the costs and expenses of the injunctions in this case. As regards the case law, the Court of Justice case law repeatedly confirms that conditions and modalities are a matter of national law. And not surprisingly, as a consequence, none of the Court of Justice case law states that it is a requirement of these intermediary injunctions that the intermediary should pay. Lord Justice Kitchen said that the CJEU contemplated that the intermediary would pay, and he relied on two authorities, one being L'Oréal and the other being UPC. I'd like to take my lords to UPC. That's at bundle 1B, tab 32, page 1110. Now, this was a case concerning the compatibility of a copyright blocking injunction with Article 3 of the Enforcement Directive. And we can pick it up on page 1116, paragraph 43, where the court records that the conditions and that the rules for the injunction against the intermediary under Article 8.3, which is the copyright equivalent provision of Article 11. Although I should say Article 11 also includes copyright. So in effect, Article 8.3 becomes OTOs. But the court here records that the rules for injunctions against intermediaries, such as those relating to the conditions to be met and the procedure to be followed, are a matter of national law. The second thing to note is that this case concerned a reference from the Austrian court. And as a matter of national Austrian copyright law, it is the obligated party, in this case the internet service provider, who is required to bear the costs. We see this explained clearly in one of the academic articles that we cite, and which is in volume 3. Volume 3, tab 57. This is an article from Martin Husevich concerning website blocking injunctions. And the particular paragraphs I would like to draw to my Lord's attention is on page 1623. On the left-hand side, it's the first full paragraph, the one that starts to provide a small preview. If I could just invite my lords to read that paragraph. Like 10 minutes over, but I think it's going well. So the point I particularly rely on is the last sentence, which is that Austrian practice doesn't grant reimbursement costs. But the paragraph overall is quite helpful because it gives a useful flavour of the different procedural approaches of the different member states.
I see it said that the French courts do require indemnities, which I think the contrary is suggested in the appendix to the respondent's case.
Yes.
Unfortunately, it doesn't give an authority for that.
No. But the Austrian authorities in the respondent's case are entirely consistent with this statement in Husevich's article.
Well, but it doesn't say Austrian law, it actually says Austrian practice.
Yes.
And it seems to cite some Austrian article and an Austrian Supreme Court decision.
The Austrian Supreme Court decision is the one referred to
We've got.
in the appendix. I think I'm right.
It may well be. Let's have a look.
The point for our purposes is nothing more than this. Because it is a procedure of Austrian law that the costs are imposed upon the party, the subject of the injunction, that's why in the Court of Justice decision there is an assumption that the intermediary will pay. So if we look back at the Court of Justice decision in UPC at paragraph 50, that's the paragraph that Lord Justice Kitchen relied upon. It's on page 1116. And it does nothing more than proceed on the assumption that the intermediary will pay, and that's because it reflects the underlying practice of national law.
Reflecting the underlying practice of national law, in this case,
Being Austrian
Austria.
law,
Yeah.
and being, therefore, one which imposes the costs on...
Did the Advocate General say anything about this?
Yes, actually, there are some passages, and we realise that the Advocate General's judgment is not in the bundle.
No.
Opinion. But just for my Lord's note, we see reference to this Austrian procedural practice in the Austrian cases that my friend relies on. By way of example, at tab 65, page 1752, where there's an express statement that the injunctive relief is characterised by the obligated party having to eliminate the nuisance at its own expense. And then there's reference to law which supports that proposition. And again,
Whereabouts is that?
That's tab 65.
I've got the page.
1752, in the middle paragraph, right in the middle. The injunctive relief is consequently characterised. It says the obligated party has to pay at its own expense. And we see an equivalent statement at tab 63, page 1723, right at the bottom, last sentence, the provision contained in Article 81 of the Copyright Law results in a provider having to bear the cost of any blocking measures.
Right, that was what page?
1723.
So it appears to be statutory.
Indeed. So it is a matter of national law in Austria that the ISP will always pay. So you have to bear that in mind when you read the UPC decision. The UPC decision itself doesn't address the question of who should pay, and nor would it, because that's a question of national law. It proceeds on the assumption that the ISP will pay, because that was the condition and modality of national law in respect of that reference. We see this coming out of a number of the other national cases which my friend relies on. Another example being the Finnish approach. My Lord, see that at tab 66, page 1780. It's in the middle of the page, the paragraph that starts under section 60C sub 5. The party requesting an injunction is not liable for costs arising from the implementation of the order unless the claim is abandoned. And then the last sentence, thus the implementation of the injunction at Eliza's expense, Eliza was the ISP, is consistent with the Copyright Act at this stage. And then on the next page, under the heading Legal Costs, right at the bottom of 1781, under Chapter 21, Section 1 of the Code of Judicial Procedure, the party that loses the case is liable for all reasonable costs. And then if my Lords flick over and then pick it up 4 lines down. However, ELISA has not violated copyright through its own activities, nor has it denied there is any copyright violation by the service. Thus, ELISA's position in this trial is relatively formal, resembling closely that of a person to be heard despite having a major interest in the case. Therefore, pursuant to the legal guidelines implied by the Supreme Court, considering the nature of the case, it's not liable for the rights holder's legal costs.
That's the costs of the litigation.
It is the cost of litigation, which...
Not what I can say.
Well, the costs of the litigation are an issue here too.
Yeah.
Yes. And we simply draw that to my Lord's attention because it's another example, both in terms of implementation costs and costs of the application of the injunction, where another member state has adopted their own national conditions and procedures in respect of that injunction, which is exactly what we're asking my Lords to do here. And the point of spending a little bit of time on these cases it is threefold. Firstly, because they demonstrate that the other member states consider the question of costs of implementation and legal costs to be a matter of national law. We say that's entirely consistent with the provisions we've shown my Lords in the directives this morning. Secondly, because these authorities demonstrate that contrary to what's written in my friend's written case, there isn't a consistent approach from the other member states based on an interpretation of Court of Justice jurisprudence. There isn't a consistent approach where the other member states have said that the Court of Justice cases impose the costs on the ISP. And so, my Lords, the summary presented in my friend's written case at paragraph 48 is not correct. Beyond that, we say these national cases aren't of any use because they're applying their own national law, and that can't help my Lords with the right law to apply in this case.
Well, the more pertinent one may be the Irish case, because that's a jurisdiction in which the basic framework of costs law is the same as us.
Yes, the Irish case itself was quite complicated. The particular injunction was not comparable with this injunction in any meaningful way, and the outcome in that case was a 50-50 cost split. So because
that's on the costs of the litigation or the costs of the implementation?
The cost of the implementation, yes. The ISP was being required to undertake to provide new software and infrastructure. There were quite significant capital costs, and so the reasoning...
Was that all it was being asked to do, or was it also being asked to pay the marginal costs of using it thereafter?
It was both.
Both.
And the costs were split 50-50 between the two parties.
Both capital and revenue?
Yes. Oh, I'm sorry, I might have got the split wrong. Is that 20? In respect of capital costs, the rights holder paid 20% and the internet service provider paid 80%. And in respect of implementation costs, I think it was 50-50.
That's the Irish case,
Yes.
isn't it?
Where do we find it?
I thought implementation costs were all to be borne by the ISPs.
Oh, my Lord might be right. I'm sorry. Yes, my Lord is right.
Yeah.
Where do we find it? Is that 70?
It's tab 70.
Page 70.
Yes. I mean, do we get any impetus against your submissions from the fact that we don't seem to be able to point to any court which has adopted the view you're urging on us?
Unless the article we've been referred to is right about what it says about the French courts.
Yes. And actually, the French decision does say that if it's a matter of proportionality, if the specific measure required were really complex or costly, it might be disproportionate to throw the whole cost on the ISPs. So
Yes, indeed.
I think everyone accepts it's a question of discretion.
Yes,
ultimately.
indeed. But to answer my Lord's question, no, it doesn't matter at all. And that's because this isn't a point which requires harmonisation across the EU. And the reason it doesn't require harmonisation across the EU is because that has nothing to do with the purpose of the Enforcement Directive. The purpose of the Enforcement Directive is to ensure consistent protection of intellectual property rights. That protection, in this case, manifests itself in the form of the availability of the injunction. And that availability is harmonised across the EU, and that's all that matters. And remember the point I made this morning, which is that these orders are jurisdictional in nature, and they are specific to the particular internet service providers against whom they are made. And so the
could have an internet service provider that carried on business across national borders, but as I understand it, the injunctions in the present case only require the blocking of sites to UK users.
That's correct, yes.
Right, where are we going? Because you're slightly over your time, I think.
I am over my time, so I shall wrap up very quickly. I just wanted to end with 2 points. The first was a policy points. We've set them out in our written case at paragraphs 189 to 211. I don't have time to expand on them in any meaningful way this morning.
Paragraphs 189 to where?
211.
Okay, right, thank you.
But I obviously urge them upon my lords.
Yes, right.
And lastly, I wanted to deal with the wider impact of this case and the Section 97A point.
And also perhaps the...
And the M&Os.
Yes, exactly.
Indeed. So, to be clear, this case obviously involves trademark infringement and only trademark infringement. But the court below approached the question of costs by importing the reasoning from the Section 97A cases, and in particular, the Newsbin 2 case, and took that as the starting point in this case also. We challenge that reasoning in the context of this case. We invite this court to adopt a principal approach to costs instead. We don't seek to go further than that in this appeal. We certainly are not trying to appeal the Section 97A cases via the back door, as has been suggested in some of the interveners' written submissions. What we do say, though, and we recognise and we draw it to my Lord's attention, is that if my Lords accept our criticism of the reasoning of the courts below, it is likely that future copyright cases will need to revisit the proper approach to costs. That's not something for this court to decide, but it's something that we are obliged to draw to my Lord's attention. There are detailed arguments presented by the respondents and the interveners as to why the safe harbours will be engaged in a copyright case, even if they're not engaged in a trademark case. But as I've already explained to my Lords this morning, that is simply wrong in respect of an internet service provider. And the reasons are carefully articulated in the M&O submissions at paragraphs 27 to 35. They explain the impact of Recital 27 of the Information Society Directive and also Article 5.1 of the Information Society Directive.
Paragraphs again?
I'm sorry?
Paragraphs
27 to 35.
So they explain recital what?
27 of the Information Society Services Directive. That was the recital I referred to earlier this morning, the one that makes clear that the provision of physical services, physical facilities, to provide a network does not amount to a communication to the public.
Yes.
It's on page 487, tab 6. The mere provision of physical facilities for enabling or making a communication does not in itself amount to communication within the meaning of the directive. And in the M&O submissions, they refer to the most recent authority, the Filmspieler Authority, which is the one that makes clear about the level of knowledge that's actually imposed on the individual before they are deemed to be a communicator to the public. And as I've already explained, that level of knowledge simply cannot apply to the internet service providers. The other point, just to remind my lords, is that one of the arguments in the interveners' written submissions is that Section 97A, because it is a statutory provision, somehow therefore encourages a different approach, such that even if my lords accept the arguments that we have presented in the context of this case, they cannot apply to a Section 97A case because of the statutory basis of the injunctions there. However, we've already seen in the Miller Brewing case this morning that the cost principles apply equally in respect of equitable duties and statutory duties. So too in the Morava type situation, which is now enshrined in statute. Lastly, the argument is that there's a different knowledge requirement, and that somehow makes a difference between the copyright case and the trademark case. In fact, the knowledge requirements are the same in both cases, because Mr. Justice Arnold, at first instance in this case, carried across the same knowledge requirements in the Section 97A case to the trademark case. And as was made clear in Mr. Justice Arnold's decision at first instance, knowledge in both types of case only arises once the internet service provider has been given notice of the application and has had time to consider it properly. So, my lords, we say that the English law takes a clear and consistent approach to reimbursement of compliance costs and legal costs in respect of innocent parties who are the subject of injunctions. We say there are sound doctrinal and policy reasons why the same approach should be applied here, and that the intermediaries before my lord should not be treated any differently from any other kind of innocent party who comes under a duty to assist. They shouldn't be singled out for some kind of punishment which isn't faced by banks in a banker's trust kind of situation, or a Morava kind of situation, or any of the other kind of offline providers one might think of. Certainly EU law doesn't require a different approach. The benefit of our approach is, apart from anything else, it's technologically neutral, which, as my lords know, is quite an important principle behind these EU provisions. We say that the internet may be a new medium, but the problem in this case...
You've really got to wrap up.
Yes.
That.
The counterfeiting problem is an age-old problem. My lords, unless I can help you further.
Thank you very much indeed. Mr. Riordan,
Nothing to say.
anything you want to add? No? Right. Right, Mr. Speck.
Lords, first of all, a very quick route map as to where I'm going to take my lords. First, I will address the subject of the internet, the role of intermediaries in its operation, including explaining the scope of the entities that are included, the difficulties of preventing illegal users, and the intermediary's special place in that setup. Then I'll address the nature and the scale of the problem of counterfeit and pirate goods and the voluntary schemes that are run by intermediaries. Next, I will explain the structure of blocking orders, how they work, what costs are involved, which parties pay them, and we can do that by looking at the detail of the order in this case. Then I'll look at the key legislative provisions, in particular the trio of EC directives that are at the heart of this case. Next, this is item 5, I will summarise our case, including explaining how the cases of the CJEU all support our submission. Then I will move on to how the ISPs say the judge erred in the exercise of his discretion in this case. And that, as I understand it, is primarily an argument about an alleged jurisdictional inconsistency, said to involve the analogy with Norwich Pharmacal. Now, that will involve looking at what was actually done in the courts below and being very careful to distinguish between two different doctrines that one sees in the Norwich Pharmacal case, the one in the Court of Appeal and the one in the House of Lords, because they are different. Then I will hopefully briefly address what my friend refers to as additional reasons that support her. Many of these are just simply different ways to characterise intermediary injunctions as similar to Norwich Pharmacal. And the broad answer is that there are substantial differences that my friend ignores, and the only real similarity is that they are not liable as a tortfeasor. And I'm going to explain that even in the detail of that aspect, they are very different. Some of the other points relied on my friend are way too general or vague to be helpful in the analysis. For instance, an additional point is sought to be made because both Norwich Pharmacal and this injunction is discretionary, so are all injunctions. So the first topic, if I can move to that, is to explain a little bit about the internet and the intermediaries whose equipment and services enable it to exist and operate. The intermediaries are a category of business that provide a variety of services that make users of the internet, from individuals to large business, able to communicate information and content to each other. And that class of internet intermediaries includes parties who provide server space accessible on the internet for people to store and make available information or content. It may be hosting for individual websites operated by third parties. It also includes those that provide online space with additional functionality and attraction for users, such as space on YouTube or a place to offer goods as part of a marketplace such as eBay. But it also includes social media type platforms such as Facebook or Twitter, increasingly used not just for social interaction but for commercial purposes. They, perhaps importantly, given the distinction that my friend sought to draw a little bit earlier, don't actually store, for instance, copies of illegal films, but they do promote their availability. Likewise, it includes entities like Google, who provide a searching service whereby things can be searched and found. The class of internet intermediaries also includes businesses that provide connections to the internet, and that's what this case particularly involves, and we refer to them as ISPs, but it's a broader category. The common feature, my lords, is that they provide a service and equipment and apparatus through which others' information, communications or content is made available or transmitted online. And the reason that I want you to see that there's a broad class is because the arguments that are put forward will be said to apply to all of them. Now, my lords, the internet, as we all know, has revolutionised many aspects of our life. It is now an important part of how society and its members exchange information, including as a channel through which commerce is conducted. Unfortunately, the boost it brings to commerce, often highly beneficial, can also be harnessed to equal effect unlawfully. The internet has enabled small and medium-sized businesses to access markets on a scale that simply could not have been contemplated without it. But that same unprecedented level of access to people worldwide can be deployed by unlawful users. Not only does it mean specific individual illegal activity can reach many more people and therefore is correspondingly much more damaging, but because of the internet's distributive nature, it makes taking direct action to stop unlawful users particularly impracticable. Their whereabouts may be impractical to ascertain, and in any event, the place where they are located may not be the location of the computer or server connected to the internet, which makes their material accessible. And my lords, even if every effort is made to chase them down directly to put a stop to their activity, it often results in the material simply being moved to another place. So months of effort can be circumvented in minutes simply by swapping to another server, often in another jurisdiction. Now, the reason that I explain all that is so that my lords see the bigger picture and understand, when I come on to look at the particular place of the intermediaries, why they enjoy a special position, and that is recognised, as I will explain. Now, a significant aspect of the problem of unlawful use of the internet is intellectual property infringement. Now, in saying that, I'm not seeking to suggest that there are not other kinds of illegal use. It may be criminal promotion of terrorism or race or hate crimes, or it may be something that the ISPs specifically do act to address, the availability of child abuse materials. Another example might be the publication of defamatory material. But intellectual property is a major area of wrongdoing on the internet. And there are two key but often overlapping types of infringement. Infringement of copyright or copyright type of rights, by which I mean to include things, for instance, like performers' rights. And those goods are often called pirate goods, and infringement of trademark rights, often called counterfeit goods. Now, my lords, it's important to understand there's no hard and fast division between them, as I've explained in paragraph 3 of my case. Many activities will involve possible infringement across both, such as the illegal download of a sound recording or a film, where titles and performers' names may also be trademarked. Similarly, counterfeit goods may also involve copyright infringement, perhaps the design of a logo. It may be a trademark, but it may also be protected as an artistic work in copyright, or perhaps underlying graphical designs applied to products or packaging. So there's a category which you can see two types, but there's often a big overlap. And again, the reason that I'm inviting my lords to look back and see the bigger picture is because we have two specific provisions that relate to injunctions. The earlier one is the copyright one, and the later one, as my friend accepts, actually covers copyright as well, but has been extended to other rights, including trademarks. But often the facts are such that they will straddle both of them. Another thing to bear in mind about the internet is that it's thrown up legal challenges as to the legal viability of those who provide the services, equipment and apparatus that may be used by others, i.e. the intermediaries. I'll give you some examples. The technology involved in electronic equipment and communication on the network involves things that we as users don't perceive, like making multiple electronic copies, such as in the memory of individual devices or routers that make up a network, or in the cache memory of servers or routers. That is a reproduction, and so if what's being copied involves copies of copyright works, you have the prospect of copies all the way down a chain and in intermediaries' devices. As we will see, the Information Society Directive acted to bring in an immunity for those kinds of activities. So that's a further one that we haven't focused on yet. And other intermediaries also face the possibility of liability for material published on their servers, for instance, offering and making available copies of a sound recording, or, for instance, defamation, as I've just explained. And one of the points that I'm going to, where we're going to go to, is that what was necessary was a sweeping away of those legal uncertainties for the class of businesses that are intermediaries. And that is what's happened, and that's what's recognised, for instance, in the judgment of Lord Justice Kitchen in the court below. And that is part and parcel of a carefully calibrated package, which is part of recognising the intermediary's special position, but so is the responsibility that has been imposed on them as well. And, my lords, I also say that this is just simply part and parcel of those, that special position being recognised again and again in different contexts as we've gone forward. An early example was the ISPs themselves voluntarily recognising their position came with responsibilities to implement means to block access to child abuse materials. What they do, and this is explained in the judgment of Mr. Justice Arnold at paragraphs 28 and 29, is that IP addresses and URLs notified them by an organisation called IWF are updated into their systems by an automated process, so it doesn't cost any significant amount of money, based on information that's provided to them, I believe, twice daily. My Lords, a further example of that same recognition of their special place was that which resulted in the ISPs being subject to considerable government and public pressure over the filtering of the types of content which, while not unlawful, might be considered undesirable and particularly something that individuals may wish to prevent access to. Most obviously, parents worried about the content that their children see. The Big Four, that's my friend's client BT, and the three ISPs who do not pursue an appeal in this case, Sky, TalkTalk and Virgin, agreed to offer parents network level filtering in 2011. And again, you'll see that as a topic covered at para 33 to 37 of Mr. Justice Arnold's judgment.
What was the electronic reference?
Mr. Justice Arnold, paragraph 33 to 37, and just for completeness, Lord Justice...
Electronic, where do we find that?
Oh, I do beg your pardon. 213 and 214.
Yeah.
And Lord Justice Kitchen at paragraph 15, which is at 202. As a result of those other recognitions of their special place, they have systems that can and do block huge quantities of website. One can choose to select whole categories, all of pornography, gambling, even all social media, including Facebook and Twitter.
I don't quite see what you extract from the fact that ISPs have accepted certain responsibilities, perhaps under some public or governmental pressure. That's a rather different kettle of fish, isn't it, from being required to accede to the particular commercial interests of trademark owners.
On its own, I agree.
Yeah.
What I get from it is that is, first of all, it means that they have the facilities to do it. And so the request for capital contributions needs to be seen in that light. My friends dropped it in this court, but it was made in both the courts below. Secondly, what I do say, I'm going to come on and develop it. I'm going to say that when you look at the EU legislation, you see the same recognition again. It's a scene setting to show that people in the past have recognised their special position, and you see the same recognition again in the package of measures that have been adopted in the EU legislation, which are the foundation for the exercise of the jurisdiction to grant this injunction, both for copyright cases and trademark cases.
And you're going to extend the submissions you make to the mobile network operators who basically support the appellants and say that the argument you're applying, if applied to them, would be very burdensome, I think.
Well, let me just address them head on now, because it's a separate point. The thrust of their point is that they don't have the facilities to do it.
Yeah.
And that may well be mean that the assessment, the balance that one has to carry out, and it is a balance when one looks at proportionality, results in a different answer. But that balance has been carried out in this case, and I do draw attention to the fact, because of what I've just told you, that the ISPs who are respondents in this application, and in particular the appellants in this case, do have the ability to do it. And I'm going to show you actually that what the costs are that we're talking about are not actually costs of doing anything more than monitoring our monitoring. But I'm rather jumping ahead at the moment.
I don't say you'll come onto it, but the approach you're outlining sounds rather like the approach of a French court. I mean, it appears to have found implicit in the directives the idea of the ISP's social responsibility to contribute to the cost of combating intellectual property infringements, provided the contribution remained within the limits of proportionality.
Well, my Lord's ahead of the game, because that particular phrase, combating the intellectual property infringement, which you've taken straight from that judgment, is exactly what I say their obligation is. And it's not, I'm setting the scene now, but when you look at some of the recitals in the directives, you see the same recognition, you see the same thing. And I'm going to take you through rather more of the directives than my friend did, but you see it there. Mr. Brandreth says that apparently I should have told you 298 for the parental controls in Mr. Justice Arnold's judgment.
Thank you. Yes.
298.
298.
Now, my lords, very quickly, a word about the scale of the problem of counterfeit and pirate goods. It is a truly massive issue, and again, so that my lords have the references, it's dealt with in the judgment of Mr. Justice Arnold in paragraph 12, and so that is 291, 12 to 14, bridging 291 to 292. And you see in that judgment a reference to a 2011 report entitled Estimating the Global Economic and Social Impact of Counterfeiting and Piracy. Note the title includes the social impact. This is not just about the economic interests of rights holders. And just to give you a flavour, what you see there is that the estimate was that globally it would be $960 billion in 2015. That was an estimate looking forward in 2011. So that's paragraph 12. It is a massive problem, and as Mr. Justice Arnold explained, the internet is an increasingly important channel for this trade. That's paragraph 13. I accept, and of course that's why I'm here, that the trade is very damaging to the rights holders, but it is not only an issue for rights holders. It's one for consumers too, the economy as a whole, and society as a whole. We've explained in our case at paragraph 16 that consumers obviously have an interest in the quality of goods that they buy. So counterfeit goods are a problem for them. Moreover, for some goods, there may well be additional safety issues. Think about electrical goods, for instance. And there is the adverse impact on the incentive for the creative process, which is the rationale for many IP rights. Certainly copyright and related rights. And again, my lords, we will see those broader concerns reflected in the key EU directives. Another thing that we see in those key EU directives is encouragement to voluntary schemes and, in fact, express reference to intermediaries being under a duty to act to remove or disable access to illegal material. And as you know, I have pointed out, and we say it's no surprise that many intermediaries operate voluntary schemes where illegal material can be removed or access disabled. And as we've said in our case, they're all operated by the operators of those platforms and other services without charge for their use. And let me just say this, because my friend tried to suggest that all of them would be straightforward hosting type scenarios. You'll have seen that we listed very many, and they included things like Google, who are not hosting, they are search engines who index things. So it is not limited to somebody who would necessarily fall within that Article 14 exclusion, and certainly not such as I think my friend said to my Lord Sumption, all they're doing is implementing something to stop them falling outside of this exclusion. It is more broad than that. And what we say is those intermediaries are recognising their responsibility and setting up and operating schemes that are dealing with huge numbers of complaints about illegal information or content. Not all of them, but a lot of them will be to do with IP infringement. Now, I mentioned this.
Are you saying that you're really acting in the public interest when you seek an injunction? You're acting in your own interests, aren't you? Your clients?
Indeed I am, but I am relying upon the broader public interest to support a submission to my lords as to what the right thing to do is. And the reason that
you should get some public benefit through having this borne by users and consumers generally rather than by yourself.
Well, if what you mean is the cost is passed on by the ISPs to their customers,
Yes.
one could also say it the other way round, in that the cost of our consumers bear the cost if we have to pay.
I think what you say is that there's a public interest dimension here.
Yeah, indeed.
If your argument is right and it encourages providers to be vigilant, then so much the better.
Indeed, and exactly the way the French court put it. They are obliged to share in the combat against intellectual property infringement.
Well, it's not a question of them being vigilant, because
Yeah,
they have
vigilance the wrong way.
no means of knowing which the infringing sites are. They don't access them or have access to the content, as I understand it.
No, and in fact, when we look at the threshold conditions, there's no question of any relief being granted against ISPs unless and until they have knowledge of specific infringements.
Which you give them.
Exactly.
Yeah.
And that's actually quite important, not only from a practical point of view, but also when one starts to think about the innocence of a party who is providing a service, making a lot of money out of it. And another way it's put in one of the cases is these injunctions stop them from allowing their service from being continued to be used to infringe. That's exactly what's happening. They know about it, and we have a right to get an injunction to stop them continuing the allowance of that infringement using their service, and they are central actors. Anyway, I'm rather jumping ahead. The reason I mention these other voluntary schemes is not just to draw a parallel between these intermediaries and the others who act voluntarily, but to draw attention to a likely effect if you accede to their submissions. Currently, these other intermediaries would be susceptible to injunctions if they did not operate voluntary schemes. So, for instance, the example I've given, my lords, of Google, they were including a counterfeit site in its listing. You can apply to Google and get them removed. But just imagine if they know, let's put it this way, they know they're susceptible to an injunction to force removal or disablement of access otherwise. But one of the knock-on effects you need to be aware of is that if a decision is that intermediaries should be paid for taking action to stop their services being used to infringe, that will provide an incentive on all intermediaries to ask for payment. They will say, look, we recognise that we can be compelled to do this, but only if you pay. And they will start to do so, or at least many of them will. Another point to note is perhaps a subsidiary point to this, though, is that if for many types of intermediaries, not these ones, but for many, an injunction to secure removal may be something you only need to do in one jurisdiction. And if you start saying that here we're going to allow them to charge, not only do you basically risk the incentive that they're going to stop doing it voluntarily and start charging, but you end up with them saying that we're only going to do it if you go to the UK courts and not elsewhere, because that's the place where we get paid. So I want my lords to know very clearly, or see very clearly, what the bigger picture is in the overall justice of the situation as to how the internet currently operates and the potential effect that this will have if you accede to my friend's submissions.
What's the present jurisdictional basis as a matter of interest? I mean, you say they may insist on you going to some other jurisdiction, but how is jurisdiction established at the moment? Some countries accept it, I think, on a worldwide basis, don't they? Canada and France, am I wrong?
Perhaps, but also the point that I'm making is that actually if what you do is get an order for disablement, removal of material disabling access, the effect of that against some intermediaries, even if you only go in one jurisdiction, say here, may be effective worldwide because it's available on the internet or it's not available on the internet. So if they disable it, if you went in France and got it for free, you'd have a relief that did the job for the United Kingdom and the rest of the world. I don't want to overplay that point, because I do recognise that these particular defendants, the nature of this injunction is particularly to block UK consumers from
I
access.
was going to say, that surely that's the...
No,
It's
indeed.
jurisdictional in that sense.
Yeah, indeed. And so in this, that's why I want my lords to understand it's a point I'm making looking at the broader picture of the effect of the encouragement of saying that intermediaries can be paid. It doesn't specifically arise on...
The effect of encouragement in other cases would be what? Then?
The first and the biggest one is not the jurisdictional one. It's just that they'll say we won't do stuff voluntarily without a court order,
yes,
and you've got to pay us. That's my bigger point. A very small additional point is that where you say, well, we're going to have a scheme that's very different from other places, you run an encouragement where they say, not only are we not going to do it unless you get an order, but we're going to only recognise UK and in effect, have a bit of forum shopping for orders that give that effect to injunctions against intermediaries. That's a very minor point compared to the bigger point I'm trying to make to my lords, and I'm wondering whether I was wise to try and add that on. The bigger point, the one that I really want you to see, is that you're going to encourage other intermediaries who act voluntarily.
Yes, I mean, the logic is if you're entitled to be paid, people are likely to insist on that.
Indeed,
yes,
indeed. And
yeah,
so it's much broader.
But it slightly begs the question as to whether they are entitled to be paid. Maybe it's a factor. Yes, anyway, we've got the point.
But my friend, she's slightly tried to row back from it, but my friend has advanced the point as a matter of principle, as one would expect in this court. And I'm trying to address that wider picture. If my lords are going to decide that as a matter of principle, intermediaries who are not tortfeasors should be paid, you've got to understand that it would apply to all those others as well. Now, my lords, can I move on to the next?
Can I just intervene, just asking, before we lose that secondary point you were making, at some point it would be helpful when we're looking at the foreign case law to know whether it has any particular significance. I mean, obviously we would look respectfully at decisions of a Supreme Court in France or Germany, and equally, insofar as they are basing their decision on what they find to be implicit in EU directives, that's of particular interest. But I wonder whether there are also practical reasons for which would tend to favour comity-based approach, effectively a harmonised approach to this, or not. I mean, it may be there are practical reasons about the way the internet operates which make that a sensible approach, or it may be that there aren't.
Well, I think the point that I was trying to make is a point like that. My lord's definitely got the point that insofar as you have a foreign court, say the French court, looking at the EC directives and deciding that a rationale behind it is that intermediaries should be helping with the combat against intellectual property infringement, that is very persuasive because they're looking at the same underlying law. And they're looking at the same underlying rationale of the special place that I say intermediaries take. But I also do say that it does become undesirable. It does become undesirable if one has, in effect, a Europe-wide jurisdiction being introduced with different cost regimes attached to it, and it will lead to the kind of thing that I was trying to get at with the subsidiary point I was making, which is you end up with ISPs, first of all, saying they won't make or they won't do anything without an order, but then they'll start jostling, saying that it's got to be the UK, and you end up with, as it were, unnatural forum shopping, which is undesirable, where actually what you want in this context, because of the numbers that are involved, for those kinds of people, you certainly don't want to encourage them to want a court order every time. And you certainly don't want to be doing it in a way that involves them saying it's all got to come to the UK.
And technologically, if you, for example, went to the French courts to get the equivalent of an injunction, they presumably the basis of your application would be the sale of counterfeit goods to customers in France. If that's your complaint, does the way in which technologically the blocking operates mean that you can geographically filter out French customers and block those while leaving the UK customers still having access?
Well, let me put it this way. At the moment, we're talking about intermediaries that, when their ISPs are national. And so in this case, it is an injunction that only has an effect in the United Kingdom against consumers. One could conceive of an ISP, say, in this country, moving out into the Republic of Ireland, and one could certainly conceive of being able to apply in one country to prevent access. And that's because infringement of intellectual property rights is a tort, and ordinarily, if they're domiciled here, you can certainly sue somebody for infringement of a foreign intellectual property right, subject to one exception, and that's where their registered rights and validity is put in issue. And so this is a copyright scenario or a trademark scenario. Normally, registered trademarks are not challenged, patents more often. But even in a patent case, if validity is not an issue, you could sue across boundaries. So although it's not...
Well, only if the infringer was domiciled here. If you're suing an innocent third party, you couldn't sue them on a worldwide basis, could you?
Well, you might certainly... It'd be very unlikely that they were being intermediaries worldwide. But certainly if there was an equivalent of Section 97A in Ireland and here, I do say that it's quite likely that you would be able to do so conveniently, either in Ireland or here, not both. But that isn't the fact at the moment with these parties, but it's perfectly possible for ISPs. Yeah. The point I was trying to make is for other intermediaries where what you're complaining about is material available online, say it's Google, the effect of relief that you get in France or Ireland may actually be good enough for here anyway.
Yeah. Yes, as in the, I think the Yahoo case raised that issue in France about sales on of Nazi material. But at the moment, the market for ISPs is divided up on a national basis.
Certainly, as far as I know for these, I can't say that, for instance, there isn't somewhere in the Balkans or certainly these ones, as far as we know, is just here.
Yeah.
Would that be a convenient?
I think it will, yes.
And we'll look forward to resuming your submissions at 2:00. We lost just over 10 minutes. Is that going to create a problem? If so, it shouldn't create a problem for you.
We've got an agreement that if my friend went over, she'd let me have the extra time at the end. So.
Out of her reply.
Yes, out of her reply.
No, on the end of my speech.
Yes, but it comes out of her reply.
So I thought you said after her reply. I don't beg your pardon.
Out of.
Yes.
Right, 2:00.